All right, looks like everyone has joined from the audience and will continue to do so. I want to thank you all for coming today. I'm A.G. Harmon of the Columbus School of Law at the Catholic University of America. And on behalf of the faculty, let me thank you for zooming into the first of our presentations in this year's Student Scholars Series. This is our 17th year of the program. And so we're very proud of that fact and proud to have this year's respondent joining us, Robert Friedman, who will be responding to the presentation of third-year student Christian Trowbridge. I'll ask you all to stay on mute until the presentation and response are completed, and then I'll open the floor open up to for questions, which you can signal by raising your hand using the raising hand feature, or just interrupting this, coming off mute if I don't see that. This series, just so you know, was initiated 17 years ago, as I said, in order to recognize notable legal scholarship produced by members of the student body during the previous academic year and to foster the skills associated with presenting and defending that scholarship in a professional conference style setting. Before I introduce Christian, a few words about his respondent, Robert Friedman. Mr. Friedman is a partner in Holland and Knight and practices in the area of ERISA, employee benefits, and executive compensation. He previously served as the leader of the firm's national employee benefits and executive compensation practice team, and his clients include private, nonprofit, and governmental employers. Mr. Friedman is a frequent speaker on employee benefits, executive compensation, ERISA fiduciary matters, and pension and tax planning. In addition to that, his practice includes representation of clients in matters with Internal Revenue Service, the Department of Labor, and other governmental agency, and he has been actively involved with welfare benefits plans, benefit flexible plans, and the rules relating to COBRA continuation coverage under such plans. He has experience with the design, implementation, operation, and communication of welfare benefits plans, and has been involved with such benefit plans in connection with mergers and acquisitions, reductions in force, and employee terminations and layoffs. We thank him for participating in the program today. Now I'd like to introduce our student scholar, Christian Trowbridge. Christian earned his Bachelor of Science in Psychology from Villanova University in 2022. At Catholic University of America's Columbus School of Law, he has been a member of the Catholic University Law Review. He served as a staff editor for Volume 74 and a legal lead articles editor for Volume 75. As a second-year student, he was a member of the Moot Court Association and competed at the Catholic University's National Telecommunications and Technology Competition. He has interned with the intellectual property team at the law firm DWF in Warsaw, Poland, as part of the law school's International Business and Trade Summer Law Program, and at the American Bankers Association in Washington, D.C. Through Catholic Law's Immigration and Refugee Advocacy Clinic, Christian was part of the team that represented and ultimately secured asylum for an Afghan family. He worked extensively on preparing their case and appeared at the family's individual hearing in immigration court to conduct direct examination. After graduation, he will be clerking for the Honorable Francis J. Jones of the Superior Court of Delaware, and following that, he will do a judicial clerkship with the Supreme Court of Delaware in 2028. Christian's interest in this topic began with a desire to explore an area of the law he wanted experience in and that would allow him to examine a circuit court split. He also wanted a topic that would allow him to speak with attorneys like Mr. Friedman who are involved with the cases at issue. So now I'm going to turn things over to Christian, making him the host of the program, and he will speak on his scholarship, which is entitled Fiduciary Breach Under ERISA, Who Bears the Burden of Loss Causation? Christian.
Thank you very much, Professor Harmon. If you can just give me a moment to share my screen. Okay. Okay. Is everybody able to see? Good.
We
Okay.
can see.
So my topic for my law review article was fiduciary breach under the ERISA statute, specifically the issue of who bears the burden of loss causation. So this is an issue involving a federal circuit split. But before getting into the details of the circuit split, I think some background on ERISA is necessary. So ERISA is the Employee Retirement Income Security Act of 1974. And the main goal of this statute, one of the main goals, is protecting the interests of participants um, in employee benefit plans and their beneficiaries. It was introduced because Americans were concerned that their funds in the retirement plans were being abused or mismanaged, and they wanted some kind of statute that would provide a cause of action um, to combat that abuse or mismanagement. So the specific provision of the statute that is at issue in my article is section 1109A. So this is when a fiduciary with respect to a plan breaches any of his fiduciary responsibilities, obligations, or duties. They will be personally liable to make good to such plan any losses to the plan resulting from each such breach. So kind of explained in easier language, and then the way that courts have looked at this when they write their opinions, the basic elements are a loss to the plan, a fiduciary breach, and finally showing proof that the fiduciary breach caused that loss, which is also called loss causation. So the Federal Circuit split is specifically on the burden of proof for that third element, loss causation. Courts are in agreement that the plaintiff is the one who's proving a loss to the plan and a fiduciary breach, but courts are split on who must prove the element of loss causation, whether the employee, the participant in the plan, must prove it as the third element, essentially, or whether the defendant employer, the fiduciary of the plan, whether they have to disprove loss causation and show that their fiduciary breach did not cause that loss. So what I'm calling the anti-burden shifting courts are the Sixth Circuit, the Seventh, the Ninth, the Tenth, and the 11th. And as I was reading these cases, I noticed we'll get to the pro-burden shifting courts in a few minutes, but some of the courts, when they address this issue, address it very, very briefly. So they'll say, for loss causation, the burden's on the plaintiff with no further explanation. But the 11th Circuit for the anti-burden side and the First Circuit for the pro-burden side have very long sections detailing the court's reasoning and analysis on specifically why that burden should or should not shift. So those are kind of the two landmark cases that I looked at on either side as I was doing my research. So the 11th Circuit case is Pizarro versus Home Depot, Inc., which is the most recent federal appeals case to have dealt with this issue of burden shifting for loss causation. This was in 2024. It was a class action by employees against Home Depot for violations of ERISA's duty of prudence. And the judges on the 11th Circuit held that the burden of loss causation would be shouldered by the plaintiff. And their reasoning for this was following the default rule from a case called Schaefer v. Wiest. Schaefer v. Wiest is not an ERISA case. It has nothing to do with ERISA, but it did lay out the doctrine of this default rule that the burden will rest on plaintiffs regarding the essential aspects of their claims. So the 11th Circuit held that the plaintiffs must not only prove fiduciary breach and a loss to the plan, they will then have to also prove loss causation, that loss was a result of the fiduciary breach. The Pizarro court seemed to be very focused on the procedural nature of this, and were very hesitant to stray from the default rule, saying that it would turn the usual principles of civil liability on their head, and that it was impossible to look at the text and structure of ERISA and conclude that this loss causation element was anything else than a core element of the plaintiff's case, that there was no way that it could be something that could be then shifted to the defendant to disprove. And just recently, in January, the writ of cert to the Supreme Court was denied for this case. So this was kind of something I was keeping an eye on since I submitted my article last spring. And because the Supreme Court has rejected this, there even now is still no consensus that the federal courts of appeals can look to. This circuit split still remains at that level. So the pro-burden shifting courts are the First Circuit, the Second Circuit, the Fourth, the Fifth, and the Eighth Circuit. And my analysis, like I mentioned earlier, focuses a lot on the First Circuit because of um, the very good argument they laid out on why the burden shifting to the defendant, the fiduciary, um, it does not conflict with the Schaffer default rule and is in fact the more equitable approach, and as well as deferring to the common law of trusts. So this case is called Brotherston versus Putnam Investments. It is also a class action by employees against Putnam for breach of fiduciary duties under ERISA. This court held that the fiduciary shoulders the burden of disproving loss causation, and the reason is because they place this greater importance on a deference to the common law of trusts when the ERISA statute is silent, as well as a great argument that the deference does not actually conflict with the Schaffer default rule. So there were three important observations that the court made. Number one is that ERISA's borrowing of trust law principles is robust. And in their discussion, you come to find out that this means when the Supreme Court is hearing ERISA cases, there is a record, a habit of deferring to trust law principles in ERISA cases. The burden application of the common law of trust best fits the balance that ERISA seeks to achieve between the interests of fiduciaries and beneficiaries. So, as mentioned earlier, it's important to keep in mind that a main reason that ERISA was enacted in 1974 was to give this enhanced protection to beneficiaries and their plan. And finally, in this case, borrowing trust law's burden of allocation rule does not pose that conflict with the Schaffer approach that the 11th Circuit was claiming that it did. So there are several cases that you can point to of the Supreme Court deferring to trust law. In 2008, LaRue versus DeWolf, this was involving recovering lost profits under an ERISA civil enforcement provision, and the court there deferred to the common law of trusts, specifically saying that it informs our interpretation of ERISA's fiduciary duties. Firestone Tire and Rubber Company versus Brooch, that involved determining the standard of review when courts are reviewing denials of ERISA benefits, and Harris Trust and Savings Bank, which involved whether certain non-fiduciary parties were to be held accountable or not on ERISA claims for equitable relief. And the First Circuit's strongest point is when we look at these Supreme Court precedents, it gives us a guideline when we're dealing with ERISA causes of action. If there is a lack of explicit direction in the statute, Congress is not explicitly spelling out what the burden of proof should be, or what the burden of proof allocation should be for this element, we look to the common law of trusts. So the restatement of trusts actually has a provision in one of its comments that almost mirrors the ERISA statute, section 1109. When a beneficiary has succeeded in proving that the trustee has committed a breach of duty and that a related loss has occurred, we believe that the burden of persuasion ought to shift to the trustee to prove that the loss would have occurred in the absence of a breach of duty. So the other issue that the 11th Circuit had was that the Schaffer default rule was the proper approach. That to not follow the Schaffer default rule, that to not follow the Schaffer default rule would turn civil liability on its head. But actually, in reading Schaffer, the language there kind of has this line of equitable reasoning that the burden may be allocated to the defendant when he possesses more knowledge relevant to the element at issue. When one party has a superior access to information, the ordinary rule, based on considerations of fairness, should not place that burden upon the litigant who has the inferior access of information or facts that are peculiarly within the knowledge of his adversary. One case I wanted to highlight that's a little bit different than the other circuits is the Second Circuit. So the other circuits, in reading their cases, they made a decision on burden allocation, and that case was the precedent going forward. The Second Circuit is the only circuit that has actually changed their position. So in 1998, there was a case in which the Second Circuit sided with the anti-shift side, that the burden of loss causation should not shift to the defendant. But in 2021, they changed their tune, and they had a great line that it doesn't really make sense for a plaintiff to have to guess what a fiduciary would have done had it not breached its duty, only to be told to guess again. It's more logical, it's more efficient, and it makes more sense for the fiduciary, the one with the access to that superior information, to say what it claims it would have done, and then the plaintiff can then respond. So not only is this burden shifting a more equitable approach, but an argument can be made it's the more judicially efficient approach as well. Uh, I didn't only look at cases. I tried to diversify the different sources I was looking at. So um, I wanted to look at what the U.S. Department of Labor had to say as an industry expert. And that was good. When I started doing my research, I lucked into finding the amicus brief for the Pizarro case early. Um, the arguments that the Department of Labor brings up in that brief are most of the same as what the pro-shift courts have argued, or the reasoning they've laid out. That when between innocent beneficiaries and a defaulting fiduciary, the fiduciary is the one who should bear the risk of uncertainty as to the consequences of its own breach of duty. And again, the amicus brief also heavily stresses this equitable concern that fiduciaries are the one who are going to possess superior knowledge to the plan participants as to how that plan is run. Therefore, they are the ones who are in the better position to be able to disprove the loss causation element than plaintiffs are to prove it. Um, I also was really excited to speak to different attorneys who were kind of intimately involved in these cases. So I was able to get in contact with Kai Richter, who was counsel for the plaintiffs in the Brotherson case. So the First Circuit case where the plaintiffs prevailed. And we had a great conversation, kind of about his thoughts on the burden shifting issue and specifically like the circuit split and why I mean, he is a plaintiff's lawyer, but so biased in that direction, but why he thinks that the burden shifting allocation that the pro-shift courts have adopted is the better approach. And kind of the big thing I took away from our conversation is he said, why should ERISA have lower protections than the common law of trusts? So why should ERISA, this federal statute that's enacted to provide enhanced protections for plan participants, why is it going to have a less plaintiff-friendly burden allocation rule than you would find under the common law of trusts? In addition, I spoke to Katrina Liu, who was one of the U.S. Department of Labor attorneys who authored the Pizarro amicus brief for the plaintiffs' appellants in that case. Again, a very enlightening conversation with her. She really stressed that fiduciary duties are taken very, very so seriously, and breach of them is taken even more seriously. That when it comes to a case where a plaintiff has already proven that there has been a breach and has already proven that there's been a loss, it is the equitable approach for the defendant, the fiduciary, to then disprove that loss was caused by the fiduciary breach. In addition, she called this a practical side of things, but again, it's that equitable line of reasoning that the fiduciary knows a lot more about the plan than the participant. And finally, something I talked with Katrina was other areas of federal law that had burden shifting. So it's not a perfect comparison, but things like the McDonnell-Douglas framework for employment discrimination. This is a judge-made burden shifting framework, and we talked about how sometimes judges might be hesitant to implement, judge-made burden shifting frameworks into statutes that are silent on that. But uh, Katrina and I were both in agreement that in ERISA cases, judges shouldn't shy away from these burden shifting frameworks. Not only are they going to be more equitable for the plaintiffs in the cases? Like mentioned earlier in the Sacerdote case, they're going to increase judicial efficiency. So just a little bit of background on McDonnell Douglas. The plaintiff establishes a prima facie case. The burden shifts to the defendant to provide legitimate non-discriminatory reasons for its action, and then the burden will shift back to the plaintiff to show that the defendant's reason is a mere pretext. So I thought that point with Katrina was important, and I had a section in my paper on kind of comparing those two areas of federal law, as they involve burden shifting. So finally, in conclusion, my article definitely advocated in favor of the pro burden shift courts. I believe that the burden of disproving loss causation should be shifted to the fiduciary after the beneficiary has proven loss and a fiduciary breach. The reasons for this being a strong tradition of deferring to the common law of trusts, specifically the Supreme Court deferring to the common law of trusts in ERISA cases when the ERISA statute is silent, it being the most equitable approach due to the fiduciary's often superior access to information about the plan and how it is run, and the fact that the ERISA statute itself is meant to provide greater and more enhanced protections to plan beneficiaries. So you have to ask yourself, why then would it not? Why then would it have lesser protections when it comes to burden of proof than the common law of trusts might? So I really enjoyed learning about this issue and writing this article, and I hope you enjoyed hearing me speak about it. And I'd like to now turn it back over to Professor Harmon.
You're on mute.
Unmute myself. Sorry about that. I've just reclaimed the hosting duties. I find there's a feature down here that allows me to reclaim them without Christian having to get involved. So I've reclaimed the hosting duties. And now we'll turn things over to Mr. Friedman to conduct the response to Christian's presentation. Mr. Friedman.
Thank you, Professor Harmon. So Christian has a very good paper, very good article, and your presentation is also excellent. I have a few questions for you. So if I understand correctly, Pizarro is the most recent circuit court case involving this issue. That's right?
Yes, that's right.
Okay. So with the circuit split as it is today, why do you think the Supreme Court denied certiorari?
I think so. There might be a few reasons. As I was researching this article and beginning to write it, I found out more and more as I researched that this is a very niche issue of a specific provision of a statute, and then that specific provision is further broken down into, this burden shifting issue. So even in reading, like for example, the Brotherston and Pizarro cases, the sections on loss causation were only a little, like a section of the opinion. So this is an opinion that also looked at several other issues. So it could be that given the cases that the Supreme Court is hearing now, that it's just under their radar and it's not causing enough issue for them to feel like it's on the radar for to provide guidance on it. The current split is is acceptable at the moment. Um, I also think the split might be kind of a little bit of a difference of opinion between the circuits about what protections are afforded by ERISA. So the Pizarro court mentioned that ERISA actually gives these broader, protections than the common law of trusts might. Therefore, it's if you want to directly compare ERISA and the common law of trust, you can't just compare them with no nuance. You have to look at ERISA and see all these mandatory disclosures and reporting that is required, which a Supreme Court might look at that and say, okay, well, that's a pretty good, line of reasoning for why they are anti-burden shifting is because ERISA does provide those protections actually, such that a burden shift isn't necessary. Um, I think it might be a combination of those, um, but I think those both definitely play into it.
And if you were on the Supreme Court and you were asked to rule on this issue, um, do you think that there's a middle ground for the Supreme Court? And for example, do you think that the burden shifting in one direction or the other should always be the case? Like the cases that you've discussed a lot in your article, Pizarro and the Brotherston case involved class action, 401k class action cases. Of course, the two cases stand for the two sides of this argument. But the 401k class action cases are different than a lot of the other fiduciary breach cases. Um, because 401k participants have a lot of control over how they contribute to the plan and how they allocate their investments in the plan. So if you were on the Supreme Court, do you see if there could would do you see whether there could be a middle ground or some way of not having to decide that the burden should be one way or another in every type of case?
I do think that the topic of the case definitely matters. So like the Pizarro court said, uh, ERISA disclosure requirements combined with proper use of discovery tools could mean that ERISA fiduciaries in certain cases would actually lack this, you know, uh, informational advantage, this superior knowledge that would justify a burden shifting rule. So I definitely don't think that a court should, approach this thinking, well, ERISA broadly is meant to provide enhanced protection, so that means we're going to apply this burden allocation as a blanket rule. I think it definitely is worth looking at what the cause of action is, at specifically at what the facts of the case are, uh, as I believe the First Circuit did in Brotherston, and then making the determination on whether a departure from the default rule would be appropriate, heavily weighing, the equity of that approach versus the harm that might come from departing from a normal civil procedure rule.
Okay. Um, I have one more question for you. So um, as we've been saying, and as you mentioned a couple of times, there are a lot of protections in ERISA for plan participants, um, in enforcement, in disclosure and reporting. Um, ERISA imposes standards of conduct on fiduciaries. So is there an argument for the anti shifting that by not specifically putting the burden onto the participant. I'm sorry, not specifically putting the burden onto uh, the employers or the fiduciaries, that Congress wanted the burden to be on the participants.
So the Brotherston and Pizarro courts both made a note of mentioning that in a lot of federal statutes, there will not be an explicit assignment of the burden of proof. So again, like reading through the history of the statute, you can get an idea of what the intention of Congress was, but I was not getting the impression that they purposefully excluded, explicitly mentioning the burden of proof because they wanted to give employers this, little bit of edge back. I more read it as they have this section 1109 spelling out the elements of this cause of action. And yes, the default rule is that the plaintiffs prove the essential elements of their claim. But a court that goes in favor of the pro-burden shifting approach would not be going against the intention of Congress because I don't think that intention was there by them not explicitly saying what the burden of proof should be for that element. I think the way that a lot of these other cases have been handled is that we have this default rule, and then in the Schaffer case itself, it says based on considerations of fairness, that rule can be departed from, which I think the pro-burden shift courts were in their right to do and backed it up very well with their legal reasoning without going against congressional intent, which I don't think was present in the statute when it comes to section 1109.
Yeah. Actually, I have one more question, one more point to explore with you. So
Mhm.
the three elements for the action for a breach of ERISA fiduciary duty are breach, right? Proving a loss, and then the the last element is the loss causation. So, did the fiduciary breach cause that loss? Um, when I was reading your article, I was having a little bit of difficulty understanding how, if you prove the first two elements, that the breach occurred, that the fiduciary failed to meet its standard of conduct, and that there was a loss to the plan, how it's not just sort of automatic that the breach caused that loss. Can you comment on that?
There, there can be situations in which a fiduciary has a breach and there might be a loss to the plan, but that breach might not be related or will not be found by a court to have caused that loss. So when I was kind of reading the cases at first and deciding which side I more identified with, um, something that kind of hit for me was that in these cases, the plaintiffs have already shown that their fiduciary that is managing this plan has breached their fiduciary duty. So it can be easy when reading these cases and thinking of the elements, to view loss causation kind of in a vacuum and say, okay, well, I'm just going to look at this element. Should it be plaintiff or defendant? But I think it's important to keep in mind that the plaintiffs have already shown that the fiduciary has breached their duty and that there has been a loss. Because of that, that is really what made me identify more with the First Circuit line of reasoning that then the defendant, the fiduciary, should shoulder that burden of disproving the loss causation element.
Okay. Thank you.
Thank you.
Thank you, Mr. Friedman. Thank you, Christian. I'll open the floor up now for any questions from the audience. If you would just raise your hand using the raise hand feature, I'll recognize you in order. Stuart, you have a question?
Uh, Thank you, Professor. And Christian, great job. That was really interesting. I have, no knowledge in this area. I'm not a lawyer, so I don't know civil procedure. But it seems to me that like timing is extremely important for all of this. I assume the judge makes the decision on whether to shift the burden, correct?
Yes. So in these cases, the the courts that decided not to shift the burden basically relied on this default rule that, like all other cases, the plaintiffs should be the ones who are, you know, shouldering the burden for these elements. What the First Circuit did, and the other pro-burden shifting courts, is say, okay, we have this statute, and normally under the default rule, the essential claims are shouldered by the plaintiff, but after the plaintiff has already shown two of these elements, it makes more sense from an equity perspective as well as um, deferring to the common law of trusts, specifically for ERISA cases, to have the defendants then disprove the element of loss causation. Because if you're trying to prove or disprove that the fiduciary breach caused the loss, who is in the better position to do that? Is it the member of the plan who, is part of this plan, or is it the fiduciary who is running and running the plan and will have the superior access to the plan information?
Do you think this could, I guess what I was getting at with the timing, like, I mean, I don't know how many of these cases exist, but is it, I mean, that could really influence whether you bring a case, I would think, right? Whether, because you don't know. I mean, you don't know at the outset. I mean, that's a big deal in terms of whether the burden is shifting, and you don't know that from the start. But I'm also wondering, would this have the effect of, if the burden is shifted to the defendants, do you think that that'll result in a lot more settlements? If because it seems like like you mentioned, they have more of the information. If they now they're, I don't know. I would think that them having to disprove could result in maybe just a lot more settlements and not going fully through. Uh,
I don't know if I could say whether or not it would lead to more settlements, but I definitely think it would provide more of an advantage to the plaintiff, which may in turn lead to settlements. Um, but you also mentioned that you're going into a case not knowing who would shoulder the burden, but there you know based on your jurisdiction what the judges in that circuit, and by extension the judges in the district courts would be
okay.
what their precedent is on burden shifting. Which I talked to Kai Richter, the attorney for plaintiffs for the Brotherston case, and he said that there definitely are, certain jurisdictions where it you'd have more of an advantage as a plaintiff bringing this cause of action than you might have in another
Got it.
circuit as
Got it.
this
Thank you.
burden
Yeah,
shifting.
that's very interesting. Thanks for your presentation.
Thank
Stuart,
you.
the way these, am I allowed to say
Of
something,
course.
Professor Harmon?
Yes, absolutely.
The way that these cases go is that in the 401k plan class action area, the employers try to win the case at summary judgment and not let it go to a full trial.
Okay.
So in it the circuit in which the case is sitting is very important, because in that summary judgment motion, and then for the plaintiffs to be trying to overcome that, they, depending on which circuit you're in, they might have to, right, show the causation. So it it if if the employer fiduciary doesn't win on summary judgment, most of those cases are being settled because the cost of the full-blown discovery
Yeah.
and trial is too expensive.
Thank you.
Yeah, you're welcome.
And I'll wait for a moment. Anybody else have a question? I might pose a question real quickly for Christian, Mr. Friedman too, if you want to hop in on it. Just to occurs to me, and I teach remedies, and I just was wondering, if you've established a breach, the plaintiff has established a breach of duty from the fiduciary. I mean, um, maybe perhaps this goes to Mr. Friedman's last point about this. If there's a breach established, they haven't done something that they were bound to do under their relationship. Isn't there also some kind of and maybe people make this argument, or do they, that I mean, of the two, I mean, there's something you have breached something, and at least at the very least, among the two of you, usually the punitive quality of that should be that you should have to prove that there's no causation to it. I mean, it seems that of the two, it would be at least more equitable for the party that has breached a duty to have to prove there's no consequence to it among the two.
Yeah, I think I'd like to let Bob respond too after this because I think he might know a little bit more of that in depth than I would. But I think that's exactly the argument that in Brotherson that the First Circuit was making,
That's
that
it.
you know, in most cases, yes, the plaintiff is the one who's proving these essential elements of their claim, but that word again and again, equity, equitable, it would not be the equitable approach to, under the default rule, have the plaintiff, the member of the plan, trying to show that a fiduciary breach did or did not cause this loss when the fiduciary is the one in the much better position to, and with
He
the
is right
superior
because he's
knowledge
more
to show that.
right, and he knows more about it. And he has more evidence and all. That's an evidentiary thing. But I guess my point is that yeah, but he's also the one that breached it, right? So I mean, so on top of the fact that he'd have more access to the evidence to be able to disprove it, he also is the one who should have bear the burden because he breached the duty. So I guess there's that fairness aspect to it too. So either of y'all could respond to that if you like.
I mean, Bob, if you had anything to add.
Yeah, no, I don't recall that being argued in the cases, not that specifically, but it's a good point to consider.
We'll see. We've got a few more minutes. People are getting ready to go back to class here in a minute, so I don't want to hold anybody up from doing that. Any more questions from the audience? All right. If not, I want to thank Robert Friedman for his participation in this program today, and Christian for a wonderful presentation. I'm always amazed at the quality of these efforts. Christian has obviously put a lot into this. He's exhausted the topic and has done it in such a professional way and presented this in a professional way. So we applaud him in doing that, and hopefully, as he and I have been discussing, he's going to submit this in the fall as he's doing his clerkship for Judge Jones in Delaware, and get this published because I think it makes a contribution to the field. So thank you, Robert Friedman. Thank you, Christian. Thank you, everyone, for zooming in today. We'll have another presentation from Joe Nazaro, a third year, next month, and I'll send out an email about that as we approach. Oh, excuse me, not next month. I think it's going to be in a week or two. So I'll send that out really soon to let you know about that. And a recording of this presentation and a story about it will be on our website soon. So thank you all for zooming in today. Goodbye.
Thank you, everybody. I appreciate it.